First District Court of Appeals is now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, great state of Florida, and this honorable court.
Thank you. You may be seated. Welcome to the First District Court of Appeal. This morning we have 3 cases on our docket. We'll take them in the order in which the notice has listed them. The first case is case number 21-845, People's Trust Insurance versus Foster. Petitioner, and just as a precursor note, Petitioner, we realized that we had a bit of a snafu with our electronic docketing with some of the filings, but rest assured that the panel had plenty of time to receive and review what you'd filed. So we're ready to go.
Thank you, Your Honor. Patrick Chidneys for the petitioner, People's Trust Insurance Company. I've reserved 6 minutes on rebuttal. And I appreciate Your Honor's comments because that's one of the first points that I wanted to make involved the fact that many of the arguments raised in response to the petition are effectively straw man arguments. They don't approach the very narrow issue that we've raised here in this petition, which is the blanket production of all of my clients' underwriting manuals in existence at the time of the issuance or renewal of the respondent's insurance policy. With respect to this narrow issue, this case does not involve the claim file, does not involve the underwriting file, does not involve a public records request. What we are asking this court to consider is that the discovery of my client's internal business practices and policies is not discoverable until bad faith occurs. In essence, this is a request for premature bad faith discovery. And we've cited a lot of cases. I'm just going to touch on a couple of them about the fact that the reason that this type of discovery departs from the essential requirements of law.
Now, this isn't a case where your brother has conceded that this is bad faith discovery, right? As I understand your brother's argument, it is that it is relevant to the coverage claim. There's an argument in the answer that this information could be relevant to the coverage claim, but that's another red herring. And the reason for that is because in this case, my client produced the underwriting file to the respondent. Now, I'm not saying that that is necessarily proper in every case, but the argument in this case in the trial court involved whether or not a defense related to what my client knew about this property. Those materials, whatever relates to this property, to this claim, have been produced. The only narrow scope of this petition involves the underwriting manuals, which necessarily pre-exist the claim in this case. That's why this is fundamentally different from, it's temporally impossible to link these manuals to the claim. I guess that's a little bit hard for us to review. We don't have the transcript of the hearing below. And as I understand it, your brother is arguing that your fifth affirmative defense had to do with the cast iron pipes having a pre-existing problem, and so that you don't believe that you're responsible for it. And whether your practices and procedural manual is relevant to that would be something that I would guess that the trial court hashed out at the hearing below that we're not privy to.
Again, the issue of whether there's a transcript or not, in this case, the legal issue can be determined from the face of the request, which is all underwriting manuals in effect at the time of the issuance or renewal of policy, and the trial court's ruling and my client's objection. With those pieces of information, the Doan decision out of the first district, out of the third, I believe, involved a situation distinguishing Applegate, which is the case requiring transcripts, saying that if you can determine the objection from the face of the record, which this court can, the court can review it without the transcript. Now, more to the point, the request that was received about the cast iron pipes, that information, again, it's been produced. And in our reply, we cite to the transcript in the trial court where Respondent's Counsel concedes that that material was produced. So the underwriting file, anything having to do with the cast iron pipes in this case, anything having to do with anything in this case, was produced. Now, the underwriting manuals have nothing to do with this claim. They're not in the underwriting file. They're not in the claim file. They are all pre-existing at the time all the facts in this case came to light. So everything having to do with this case has been produced. The underwriting manuals are so far afield of that, they are relevant only, if ever, to bad faith. And that is where the irreparable harm in this case arises. And that's where the court's decisions in General Star Indemnity, and in fact this court's decision in Vanguard Fire versus Goldman, which is at 955 Southern 2nd, 591, where the court recognized that requiring a party to defend against a breach of contract and bad faith claim at the same time creates irreparable harm. The reason for that is somewhat obvious. It's that you're fighting a battle on a front that may never exist. It currently does not exist, and it may never come to exist. Again, in our reply, we've cited some other cases that's very clear in the first-party insurance defense context. But outside of that, the Florida Supreme Court and many other courts have recognized that requiring a party to defend against a case that doesn't exist creates irreparable harm. I don't think there's any argument in this case that it's error to require the production of these materials. The argument...
It seems like that's right if your brother gets up and says this is all about our later to be brought bad faith claim. If he says that, then that resonates. If he says that this is discovery that relates to the coverage claim that he brought, then as it stands, I don't know what's in the manual. I don't know what was hashed out at the hearing below that the judge thought made it discoverable or not, and so it just seems that I'm in a tough spot.
There is a transcript from the subsequent hearing where Respondent's counsel did concede that everything relating to this property was produced, that the underwriting file was produced in this case. So again, the manual, just as a matter of the sequence of time, had to predate this claim. So it could say nothing about this claim. It has nothing to do with this claim. Anything having to do with this claim was produced. That's why this...
Could the manual say something about how you treat cast iron pipe leakage claims? Could it say, okay, this is the way we're going to inspect them, this is the way we're going to address them? I don't know what's in the manual.
And if there were something applying that to the facts of this case, it would have been in the underwriting manual that was produced. The way in which my client performs its contractual obligations can only ever be relevant to the question of bad faith, because bad faith in Florida is a derogation of the common law. It exists only by creature of statute 624.155. And everything in that statute describes an insurer's performance of its contractual obligations. If those obligations never exist, never come into existence, there can be no bad faith. So the manner in which my client performed the underwriting function, which frankly seems extremely far afield of anything that's been argued in this case, but the manner in which those contractual obligations are performed is only ever relevant to bad faith. It's not relevant to whether or not there is coverage, which is the only issue in this case. In the Hartford versus Mainstream case, the Fifth DCA explained it as if there is no insurance coverage, nor any loss or injury for which the insurer is contractually obligated to indemnify, the insurer cannot have acted in bad faith. The question that you posed to me involved compliance with what my client thinks it should do. That is a general business practice. It is discoverable only in bad faith. And come to think of it, the statute, when it mentions general business practice, is only in the context of a punitive damages proffer. So it's an even narrower than in the statutory bad faith. And to obtain that discovery, the respondent, the plaintiff, has to actually post the costs of that discovery. So allowing someone to get this discovery in a discovery request that was served contemporaneously with the complaint, this is a form request that's served in thousands, probably tens of thousands of cases. That's why this case is important, because these requests are facially invalid, but they go out with every complaint. And in this case, the materials were, by the trial judge, approved for production. Now, the transcript we have of the hearing on the stay motion that we filed indicates that the trial judge says, I believe my original ruling was because I thought it was a blanket privilege objection. The court can glean from the record that these materials, the pure underwriting manuals, have absolutely nothing to do with this case. And allowing the production of those materials in this context creates a severe risk of irreparable harm, because again, this goes out in tens of thousands of cases, probably more, and allowing that to happen, it creates a serious risk to my client. This is not a one-off, this case-specific request on cast iron pipes. On its face, these requests are legally improper, and the risk of irreparable harm I can't understate, because it gives someone who is not this is a repeat player, now has my client's internal business policies before bad faith ever came to light.
On the irreparable harm issue, are these manuals something that's submitted to OIR?
The manuals are submitted to the Office of Insurance Regulation, but there are a couple of points here that are very significant. The first is the request in this case is not limited to publicly available OIR records. It is a blanket request for all manuals. Now, that said, materials that are submitted to the Office of Insurance Regulation may be discoverable as a public record. There is a process to obtain public records. And, Judge, you wrote a decision in 2017, OIR versus State Farm, in which Your Honor explained the process. And in that process, an insurer can actually object to the production of those public records if they constitute, for example, trade secrets. There is a process for that. But more importantly, if simply because a material becomes a public record does not make it automatically relevant to a civil lawsuit. So
As I read the state transcript, it seemed like the judge below was amenable to hearing more about this issue as it arises. It seemed like he said there's no blanket privilege here, there's no claims file privilege, there's nothing blanket, but as issues arise, it seemed that that he was open to hearing you out. I mean, to the extent that they wanted a whole manual with a lot of irrelevant trade secret type stuff, but there were 2 pages that addressed leaky pipes or something like that. That was something that was still could be live in the trial court. Am I wrong about that? Or?
I believe it would be wrong because the order was not modified and the order remains intact. So whether or not the trial court originally, I agree with Your Honor that I think the trial court was second guessing its initial ruling and saying, I'm not sure that I meant to produce the underwriting manuals, that I was more talking about claim file or underwriting file materials. But the trial court did not modify the ruling, so it remains in effect, and we're asking the court to quash that. I'll reserve the rest of my time.
Good morning. May it please the court. It's good to be back live. Couple of things. Did you get my notice of supplemental authority yesterday?
We did.
All right, that's the Venable case. As I was prepping, I wish I'd have gotten that to you earlier. As I was prepping, I said, I know there's a case out there. And started looking, and it was my case. And so we sent that yesterday on this issue.
Of course, we prefer not to get them the day before oral argument.
I understand I was kicking myself. It did come out after the briefing. When it came out, I didn't remember that we had this thing in play. But it deals with the issue. It's a denial of petition for cert where we requested publicly available manuals. And counsel, my friend on the other side, seems to conflate claims manuals, which we haven't asked for, which would be relevant in a bad faith case only, and underwriting manuals, which will tell us the nature of the inspections that are done. And those are before the contract is formed. It's the basis for whether or not they're going to insure it or not. Counsel is correct. They did provide us with the underwriting reports and photographs. But the problem is this. They document no prior damage, which is helpful. But there are 3 questions that are typically on a verdict form in a property damage case. Question 1 is whether or not the insured can prove that there was direct physical loss during the policy period. With regard to that first question on the verdict form, we would hold up those the reports and say, look, no damage. But then they come in, because we don't have the breadth and scope of the inspection that was performed, they can come in and say, that was just a cursory inspection. Nobody was looking for this type of damage there. The manuals are going to tell us whether or not how the breadth of that inspection, how the inspection was performed, and what they were supposed to document. Most of the manuals will say you must document all damage. And so with regard to question 1 on the verdict form, the manual is critical to take away that argument from the insurance company. Question 2, if we get there, if we prove damage during the policy period, question 2 is whether or not the insurance company can prove, here their 5th affirmative defense, that the damage was pre-existing. Again, the manual is going to tell us whether or not that inspection was a cursory inspection or a detailed inspection. Question 3, then, if we get there, is the amount of damages that we prove are under the policy. It's relevant to that question, too. Again, it disarms the insurance company.
So your position is not that this is discovery that goes to whatever bad faith claim may arise. This is about your coverage case.
Exactly. It wouldn't be relevant in a bad faith case. Whether or not you're willing to issue the policy and the inspections that are done pre-contract formation have nothing to do with whether or not the claim, which may or may not rise later, was handled in good faith or bad faith. It has nothing to do with it. Their claims manuals might, but not the underwriting manuals. They have nothing to do with a future bad faith case. But they are critical in this case for our 3 questions on the
So it seems like your argument is dependent on whether it's defended by saying that, well, that was just a cursory inspection, whereas the underwriting manual will require some other kind of inspection.
Exactly. And that frequently happens.
Well, frequently, or did it happen in this case?
I don't know until if we get to trial, and and we say, look at this inspection report. It doesn't document any damage. If we don't have the manuals, then they're able to simply say, well, that was just argue. That was a cursory review. There was no intention of looking at this type of thing. While the underwriting manual, which is publicly filed, they can't have an underwriting manual that isn't publicly filed. If they've done that, they need to self-report to OIR, because all of them have to be filed. But it takes away that argument. But we got to remember our context here. We're here in a petition for cert. And they can't show any departure from the essential requirements of the law. And we're talking relevance here, which is usually not going to be the issue. I understand why the court's asking the questions, but it's not going to be the issue in a petition for extraordinary relief. So there is no departure from the essential requirements of the law. There's certainly no irreparable harm. They haven't even tried to show that. And if it comes in and it shouldn't at trial, they can just deal with
Well,
that.
Petitioner's Counsel says that there is a procedure to get the documents from OIR, and presumably that procedure would not be followed with you getting it in discovery. Is that correct?
Yes, Your Honor. And let me explain the problem with that. Problem number one is there's no rule of discovery or evidence that says if you can get something from two different places, you got to go to the other place first. Clearly, getting it from the insurance company from a evidentiary foundational perspective is much better. So one problem is this is not a rule of discovery. Second, if we get it from OIR, if we can find it, and I'll get back to that in a moment, if we get it, then we go to a corporate rep depot. And the corporate rep is asked, are these the manuals? They're going to instruct them not to answer, or they're going to say, I don't know, I'm in claims, I'm not in underwriting. But more likely than not, they'll say the same thing they've said this morning. Don't answer the question. It's categorically protected, and it's trade secret. And we're back here not on a request to produce, but on compelling the answer to that question in the depot. And the final issue would be OIR's website is very difficult to navigate. And then we don't know if those are all of the ones that are enforced at the time the policy is issued, because they're just sitting there sort of like a data dump. It's very difficult for us to get them, but then we're back to the evidentiary foundation issues, which will send us back here on that issue. So, yes, sir.
How do you characterize the cases that grant cert and quash discovery in the area of turning over manuals?
Most of those are shotgun requests, and I haven't seen one case yet. All right, we got our Venable case talking about underwriting manuals, and I haven't seen any cases talking about the relevance to our question one on the verdict form, telling us the nature of the inspection, and question two, whether or not it's all relevant to all three questions on our verdict form. None of them discuss that issue. Clearly, it's going to be relevant. We have the reports. We now need to show those reports were not cursory, but were detailed, and their inspectors are told you got to document all the damages. But again, that's issues that can be handled by the trial judge as well as handled on an appeal at the end of the case. Does that answer that question, sir? Okay. I don't think I have anything further unless you have questions. Thank you.
Thank you.
A few points in response there. I think the first point, and the one I need to make most strenuously, is that the arguments that were made there in the response establish that these underwriting manuals have nothing to do with this case. The first argument from a general level, from a high level, the respondent has conceded they have what they want, essentially that they don't see pre-existing damage. Now, if that's the case, they tell the jury that at trial, and there is no liability. What remained in the manuals has absolutely nothing to do. It's completely irrelevant to what ultimately occurred in terms of the underwriting file, what my client observed. It has nothing to do with this case. And Judge Winokur, you hit the nail on the head by asking, has that issue been raised? Has the cursoriness of the review been raised? It has not, because again, that is quintessential bad faith. the performance of contractual duties, whether it was in good faith or bad faith or in violation of some policy or procedure, that is bad faith. That is bad faith by statute. And the cases are legion that that type of discovery not only is premature, but creates irreparable harm in this case. The question there was, what is
Is that true when you're talking about a defense in the area of pre-existing, it's a pre-existing problem? It seems like to make out the coverage case, you're going to have to overcome the fact that that problem, whether it existed before or not, and so there's going to be a lot of back and forth about the nature of the inspection, what was inspected, what did the inspections show, that sort of thing.
And that would be facts involving this claim. So whether there is damage or not is a fact a jury will decide, and it will be relevant to the existing damage defense. What my client was supposed to do as a policy, what my client's internal processes are, those are business policies. Those are protected from discovery until you get to bad faith. The bad faith question being, did you perform your contractual obligations appropriately? If those obligations never come into existence, that discovery is plainly premature. This is quintessential bad faith discovery, but more to the point in the facts of this case, the respondent has conceded that that issue hasn't come up. The cursoriness or whatever of the inspection is not at issue. Nobody's raised it. So even under the facts of this case, generally speaking, it is not discoverable and it creates irreparable harm. Under the facts of this case, it's also not subject to discovery. But the irreparable...
Is it inherent? I mean, when you're having a battle of, I guess, inspection experts, you're both going to say, well, shortcomings, his inspection had shortcomings. No, her inspection had shortcomings. I mean, it seems...
The policies, my client's business policies, the same argument could be made in the claim context, that these policies, internal policies, are completely irrelevant to the facts, to what was actually observed. If they believe that something should have been observed and wasn't observed, or if my client can't produce evidence of some type of damage, the jury will see all of that. But it's the facts of this case, and my client has produced all of that. The manuals are my client's internal business policies in that context, and those are not relevant until the issue of bad faith happens, until there is a contractual obligation and coverage. The respondent is not entitled to the discovery of my client's business practices, and that is fundamental, quintessential, premature bad faith discovery that creates irreparable harm. The question on irreparable harm and the backstop on all the cases with the Supreme Court and Allstate v. Langston to the present is Rule 1.280B1. It has to be relevant to the subject matter of the pending action, and pending is the operative word. In this case, there has not been a coverage determination. Bad faith has not arisen. There is no pending bad faith.
With respect to all of the physicians in this particular practice, including, as a matter of fact, the physician that the claimant herself actually requested as a second one-time change. But in any event, there were two agreements, actually. The first agreement was entered into before the first scheduled appointment for Ms. Smith, and I believe that appointment was originally in May of 2020. And shortly before that appointment, Ms. Smith's counsel insisted on having a videographer, which is somewhat unusual when we're discussing a treating physician. This is not an IME. But the doctor would not agree to the videographer. It's not specified in the record precisely why, though there is some mention that because of COVID concerns. Suffice it to say that when there was the second scheduled appointment, the doctor did permit the videographer to attend that appointment, and the appointment did go through. Now, after the first appointment was canceled because of the videographer issue, it was then later rescheduled to, I think it was August. And before that second appointment was set to occur, the employer carrier entered into a different agreement for the same amount, the $800, with Dr. Waltz. Now, in this case, the claimant does not contend that this second agreement, which was the agreement in effect when she saw the doctor, was in violation of 440.13. So with respect to the question of whether there was in fact a violation, we believe that the the JCC erred in not considering the second agreement as the operative agreement, and in finding, in the absence of any dispute on the part of the claimant, that this agreement departed from the statutory requirements. But getting back to...
Does 44013 have a section that deals with reimbursement or payment disputes, issues? I mean, they're contemplated in 44013, aren't they? That there can be issues that arise.
Yes, there are reimbursement issues, and in fact, I think that was addressed at length in the Marine Max opinion out of this court. And in fact, one of the arguments that has been raised in this case is that the JCC really did not have the authority to find this as a basis to effectively deauthorize Dr. Waltz in this case, and that if in fact the claimant disputed the reasonableness of the charge, then really that was a matter for the DFS and not for the JCC. Certainly, it's undisputed that there is no authority from this court that a departure from the statutory requirement, if in fact there is one, permits the claimant to then choose a second one-time change, which is
a case of first impression.
This is a case of first.
An extension of a rule from the IME context, is it?
Correct. I mean, the IME cases predated the change in the statute, which actually took out a cap on the IME. So the Napier case, which all of these cases seems to rely on, is of questionable authority in the first place. But secondarily, as Your Honor pointed out, it involves an IME. It does not involve an authorized physician. And I would submit that that is a very big difference. There literally is no authority that permitted the JCC to permit the claimant to choose the one-time change. Once the employer carrier properly and timely responded to the request for the one-time change, only the employer carrier had the ability to choose the physician. Excuse me. So,
if there were a reimbursement dispute, I believe that might go to the division, and the division sort of polices that. Is there an entry point for a claimant to say, hey, I figured out what the carrier paid my doctor, and my doctor might not be concerned about that, but I, for some reason, am, and I think my doctor should have been paid more. I mean, that seems like that the claimant is kind of a third party to what the carrier is paying the doctor in an authorized treating type context.
Honestly, Your Honor, I don't know the answer to that specific question about whether the claimant could actually submit that to the DFS, but I believe I saw a number of JCC level cases finding that the claimant does have standing under these scenarios to raise an objection as to what the doctor was being paid. The irony in this case is that the argument is that somehow the payment of $800 to Dr. Waltz tainted him to the extent that he was nothing more than a second IME, and there's no evidence in the record that would substantiate it. First, there is, in fact, an IME that is already testified in this case. But secondarily, it doesn't make any sense to say that an authorized physician who frankly makes a living out of treating patients, not giving a one-time opinion as does an IME, but an authorized physician would be more likely to testify favorably for the employer carrier that there's no further treatment needed, when in fact it is not to that physician's benefit to say, I don't need to treat this patient any longer. So the argument that there was some kind of tainting going on by virtue of the payment to an authorized physician of an amount in excess of a fee schedule is simply not only not borne out by the evidence, but is nonsensical. So with respect to our first argument, we believe that the JCC erred as a matter of law in granting the claimant's motion to strike Dr. Waltz, not only his testimony, but as the authorized treater, and in permitting the claimant to then choose her own physician.
Can you, when you say not only his testimony, this is a doctor who is authorized and is going to treat. Where does the testimony part come into this case? Has he testified, or?
No, actually, because he was stricken. But what opposing counsel characterizes this case as about is whether the JCC abused her discretion in striking the doctor's testimony. But in fact, what the order provides is the doctor is stricken, is basically deauthorized as a treating physician, and the claimant is entitled to choose her own physician.
So am I right in the IME context that if there's an overpayment in the IME context, then the JCC can disregard that testimony as to the independent evaluation? But here, it just seems like it's a bit ill-fitting.
Well, the IME section of the statute that was relied on in Napier that had a fee schedule has been amended, I think, back in 2002. It doesn't exist anymore. And in fact, the IME in this case was paid $925. So that case really is of questionable relevance here for that reason, as well as the fact that it involves an IME. And our second argument, and I see I'm into my rebuttal time, but my second argument is simply that, assuming for the sake of argument that there was some defect in the first agreement between the employer carrier and Dr. Waltz, that alleged defect was cured, and that cure obviated any argument on the part of the claimant that the court should strike this doctor as an authorized physician. As I said before, there's no evidence in this record to establish that Dr. Waltz, by being paid $800 as opposed to $240, was going to be more partial to the employer carrier. So we would respectfully request that this court reverse the JCC's final order and remand the case back for further proceedings. Thank you.
It please the court. I'm Wendy LaQuasto of Fox and LaQuasto. I'm here today representing Appley Francis Smith. I'd like to, the employer carrier would like to make this case into one that's a deauthorization or that it's some sort of billing dispute, and that's where that lack of authority argument comes from. But this is simply a case, and this is what the judge found in this case, that Dr. Waltz, by the EC, overpaying him nearly quadruple what the fee schedule, prepaying him nearly quadruple what the fee schedule called for, and then pre-conferencing with him the day before the first appointment was scheduled, that he was never properly qualified to be an authorized treating physician. And so under 440.13.5, which says testimony opinions are limited to ATPs, IMEs, and expert medical advisors, he was a person who was not authorized to testify, and that's why he's struck. So it's not a question of deauthorization. It's a question of the activities by the EC and how they approached Dr. Walls and how they secured his services caused him to never be properly authorized. And that's something a JCC can decide and did decide.
How is an authorized treating physician authorized?
I'm having a little trouble hearing you.
Sorry about that. How is an ATP authorized? What is the process?
Well,
for that?
the adjuster gets to authorize that person. And so, that's what they've said in this. We authorized them. We timely authorized them when we got we have 5 days to authorize a one-time change, and we did that. And they named that person, and they did that. But ultimately, just like, there's case law out there about when you don't authorize the right kind of doctor for a one-time change, that's something a judge can decide too. So although you authorize Dr. X, if that Dr. X isn't who is required, the specialty or something like that, a judge would get to decide that's not a proper authorization. The judge also gets to decide in those one-time change cases, like if you haven't done it timely. And if you haven't done it timely, then that doctor is not properly authorized either. So there are things that can cause a doctor to not be properly authorized, even though the employer carrier has named that person.
And here that thing was billing, instead of billing $200, he billed $800. Is that?
Yeah, that and
right?
Prepaying him before he even did that. And of course, as the employer points out, the statute does allow for deviation, but no one even knew this was a deviation when it was set up, so it's kind of hard to believe that written agreement was somehow...
So the statute allows an $800 fee as long as certain...
As long as you
written,
jump through the hoops,
yeah.
And that's what this judge found, was the hoops were not jumped through. Because the first agreement doesn't say, even the people that testified, Delgado, the CEO and general counsel for the doctor's office, and Gruber, the adjuster, no one even knew it was, even considered it a deviation.
So doesn't exclusion of his testimony, considering that it was based on the fact that the fee was excessive under the statute, doesn't that really turn this into a fee dispute? I can't think of any other way that it.
It seems to be kind of a gray area, doesn't it? And the cases, and there are some cases, admittedly, that kind of say that, but and they cite some in the reply brief, some OJCC orders, but those cases assumed that the agreement that was entered into was proper, and that's a crucial distinction here. This judge found this agreement was not proper, so it failed the statute. And then if it fails the statute, then you have a doctor that's not that hasn't been properly authorized, because the statutes are replete with doctors should be paid according to the fee schedule. So this is an exception. This is, the employer carrier wants to make this statute into some sort of thing where they could go out and get anybody and pay them any amount as long as there's any sort of written agreement. And I don't think that that's what the workers' compensation system is all about. It's quality care at a reasonable cost.
Now, this is a case of first impression. Is that right? That we haven't seen in the context of an authorized treating physician this idea that if there's something improper in the fee agreement, that the claimant then gets to, I don't know if the choice of his own doctor or gets to go to the next doctor. And I don't know how many times that can happen. Maybe the second, maybe the third, maybe the fourth.
Well,
as long as a claimant.
Particular context, this, but I submit it's not first impression when you talk about doctors that aren't timely authorized. When you got a one-time change.
But that's not this case. He was timely authorized. So this doctor was authorized, but something subsequent to that, your argument is, caused him to lose the status.
But I'm just saying by analogy, those cases say when a doctor is not timely authorized, then the claimant gets to go forward with the doctor they selected. So this is not new law about if a doctor's not properly authorized, that the claimant selection gets to go forward. You know, there's those old cases about, you know, the claimant gets to get the doctor he selected during the period where the employer carrier refuses to provide treatment when you go out and do self-help and you get somebody, all of that. So I submit, yes, maybe under these express facts, it's first impression for this court. It's certainly been dealt with numerous times at the trial level.
So the closest cases you're saying are those where the 5 days gets exceeded?
I'm sorry.
The closest cases that you're relying upon are those where the 5-day period for
Well,
making the change gets exceeded?
I don't think the IME cases are a hard jump. You know, I don't know that those are, you know, I'm saying you asked as a case of first impression, and I'm saying, well, there's other areas that are similar to this. But I don't think that, and there's several cases out of this court about IMEs, and this is not a far jump. You know, these are very analogous cases, and in fact, it makes much more sense to disqualify an authorized treating for charging over the fee schedule than an IME, because everybody knows an IME is a hired expert and they're going to say what you wanted to say, and that's the reason the statute's amended, is because you should be able to hire the expert you want to be able to hire and pay them what you want to be able to pay them to get the opinion you want to get.
Do any of the IME cases just deauthorize the IME so that a second IME comes into place, or is it just the testimony gets excluded of the IME?
I'm not sure I understood that question.
Here, your argument is that the remedy is a new doctor. In the IME in the context of the IME cases, is the remedy a new IME, or is the remedy exclusion of the testimony of the IME?
Yeah. The DeCuba case said permanently that IME was permanently foreclosed from participating in the case, and Hancock says if a doctor's disqualified from being a witness, a claimant ought not to have to go to a physical there. But they do get to choose another IME in those cases. And when you're dealing with the one-time change, that's the little hiccup in it. They could have authorized somebody else when they found out the $800 and still been okay, but maybe been okay at that point. But here they have the one-time change says you have to name that person in 5 days, and they held strong on Dr. Waltz. So when they've lost that issue, the one-time change then goes to the person that the claimant selected. And so then that would be Dr. Lynn, and that's what this judge ordered.
Yeah. Do you think that because the statute has a provision dealing with fee reimbursement disputes, that fee reimbursement type issues it's contemplated that there are going to be issues along that line, and issues that are going to have to be resolved, and that in that provision, I don't see anything about that knocking doctors out. It's just that these are issues that have to be resolved according to a certain process.
Well, the division can deauthorize a physician for not following the fee schedule, and that is part of the reimbursement of remedies that they have at the division level. And it does, as you say, the statute does contemplate that there'll be disputes but that's a dispute between the carrier and the doctor. You don't have that here. You know, you've got a carrier who promptly paid with no questions asked nearly 4 times what the fee schedule and asked for. So there's no question about this is some sort of dispute about what the fee is. This is, we're going to pay you 4 times the amount of money that you should be paid to see this person. And I think, you know, Judge Owens said it in the co-opinion that it's really important that authorized treating physicians have this impartial cover over them, and that when you pay them this large amount of money, you've destroyed that impartiality. And that's exactly what Ms. Smith feared.
I guess
I was just going to follow up a question similar to what he just asked. Is there a provision in the statute that you can point us to that clearly indicates that a doctor under these circumstances is to be disqualified, or that it is not properly authorized, as you say?
Well, the 440.13.5 C, one of those, says that opinions are limited to authorized treating IME expert medical. That's very clear. And if you don't fall into one of those categories, you're excluded. And that's the basis for striking him in this case.
Well, so we have a statutory provision that says that the fee charged can't exceed the fee schedule. But does that necessarily mean that the doctor is, if a doctor is paid something outside of the fee schedule, that they're necessarily disqualified?
Well, I think the statute, it doesn't say it doesn't say, and if your written fee agreement doesn't meet the statutory requirements, you're disqualified. Yes, I agree with you. The statute doesn't say that, but it says if you're going to have a deviated fee, your fee agreement has to meet these criteria. Well, it has to be a written agreement, and it has to show you're providing quality care at a reasonable cost, and it gives examples, and none of those are here in this agreement.
Those things are to what end, though? Those things are for the purposes of actually carrying out the payment, or before the fee can be paid, that those things should be completed, or does that mean that if you haven't done those things, that person is disqualified from participating?
Stick to the fee schedule. That's what that is. If you haven't done those things, it's stick to the fee schedule. That's what that is all about. You need to be charging within the fee schedule. The exception is if you have this written agreement that meets these criteria. And if you don't, then you haven't stuck to the fee schedule. The statutes are replete with how everybody should be paid by the fee schedule, and if you're not paid by the fee schedule, prepaid $800, quadruple the amount almost, that you have shown that you're a biased person, not an impartial doctor who's going to be authorized treating, which is what that's supposed to be.
If there was a written agreement that did correctly jump through the hoops that made the that made the fee not $200 but $800, why wouldn't that affect partiality? If you're saying that that's a partiality issue, if you get paid $800 versus $200, but the statute allows for it, why isn't it still a partiality issue if you're getting paid $800 instead of $200?
Well, they've made that argument, but I submit if somebody paid me money, much more than if somebody paid my bill 4 times what I billed them for, I'd probably do a little extra work for them, go to the mat for them. Not that I wouldn't.
But the statute seems to contemplate it.
Yeah,
the statute contemplates an escalation.
Yeah, but
right?
and the whole thing is that all they're doing is all they did in that second agreement was put in the CPT code information. There's no indication. They didn't call Dr. Waltz. He didn't testify. Oh yes, I agreed to do the CLE and have this case management stuff and all the things that the statute contemplates for this advance fee. And in fact, everybody makes a big deal about second opinions needing more records, but he didn't even charge more money for reviewing more records, and he could have under this contract. So, I think that the whole thing is I think the proof is in the pudding in this case. Delgado, his representative, said he was authorized for a second opinion IME. That's what he thinks he's doing, second opinion IME. And when he actually sees her and renders his report, he disregards what the EMA says there's no more diagnostic testing, even though the EC had stipulated that needed to be done, and he disregards the EMA's opinion altogether. So I think the proof is he wasn't acting as an authorized treating physician in this case, and I submit that's due because he was tainted by the overpayment. I see him 13 minutes over. Does anybody have questions?
Thank you.
Okay, then we would ask you to affirm in total. Thank you.
Issues regarding a pre-conference or a prepayment are literally red herrings here, because that was not the basis on which the claimant sought to strike Dr. Waltz. With respect to the argument that one can analogize this circumstance to those cases involving IMEs, there is no analogy because it's very clear that the statute simply says nothing about deauthorizing a treating physician for a violation of the fee agreement, or the fee statute, excuse me. The statute, however, does specify what happens when the employer carrier does not respond to a request for a one-time change, and the statute provides that in that specific instance, then the claimant is entitled to choose his or her own doctor. Certainly, if that were an option available where an authorized treating physician violated the fee statute, then the legislature would have said that. And it hasn't done so, and therefore we would submit that, especially under the Marine Max case out of this court in 2019, Judge Windsor specifically made the point in a case in which the doctor demanded prepayment of an amount well in excess of the fee schedule. The doctor demanded payment of that, and the employer carrier refused to pay it. But this court said the law limits the bases on which an employer may officially deauthorize a previously authorized physician. It's very rare that that occurs. And there is nothing in the statute, in the case law, that supports the JCC's decision in this case to effectively deauthorize Dr. Waltz and to effectively permit the claimant to get around the one-time change statute and to choose her own treating physician. Finally, with respect to, well, there's 2 points I want to make. First, the argument was that somehow because of a CPT code that the doctor's office uses to bill, somehow that miraculously changed the authorized physician into an IME. And there is no evidence of that. Certainly, the employer carrier clearly authorized this physician to be a treating physician, and no billing code chosen by the staff of a doctor's office changes that fact. And my one final point here is what I haven't heard from opposing counsel and what wasn't addressed in the answer brief is, what about the second agreement? If everything that the claimant has argued here today is now the law, and that the first agreement in question violated the fee schedule statute, then what about the second fee agreement? There was no dispute at the JCC level or in this court that that agreement violated the fee schedule statute. And therefore, it's clear that even if, for the sake of argument, you don't agree with our first point on appeal, that the violation did not justify a disqualification, then certainly the court must nevertheless reverse because the second fee agreement was in compliance. Thank you.
Thank you, counsel. We will take a short, maybe 5-minute recess and then reconstitute for the third case. Or not reconstitute, but be back for the third case. Thank you.
All right.
You be seated. Our third case this morning is Kelly Air Systems et al. Versus Colon, case number 21-976. Counsel for appellants.
Good morning, Your Honor. My name is Rayford Taylor. I am here on behalf of the appellants, the employer carrier. With me at counsel table is Judy Blinderman, who is the trial counsel below. I'd like to reserve 5 minutes for rebuttal, if I may. And we're here today, obviously, to ask this court to reverse the judge's denial of compensability under the going and coming rule. It is our position that this case involved the application of 440.092, specifically the traveling employee provision, but 440.092 sub 2 and sub 4. Sub 2 is the statute which deals with going and coming of employees. And the legislature amended sub 4 to tie it back to traveling employees, so that traveling employees who are no longer in the course and scope of their work, i.e. they're going to work or they're going home, are covered by the going and coming rule, and injuries are therefore not compensable. That is what this whole case was about. The sole issue to be tried and the only issue that was argued to the court in terms of the statute, the application of the statute. We discussed in our brief how the legislature made it very clear what their intent was, which was to bring the going and coming rule over onto traveling employees. Historically, traveling employees were treated as if there was a basis for them not to be covered by the act. They weren't covered. That is, the going and coming component wasn't covered. So therefore, their accident was compensable, their injuries were compensable, and responsibility of the employer carrier. In this case, the judge cited several reasons why the statute did not apply and that the employee was not injured in the going and coming component. The major reason that was pointed to was the exclusive personal use provision. As we discussed in the brief, there's a case called, was originally addressed in the Gilbertson case, when it upheld the denial of compensability. The court also concluded, though, in other cases where compensability was denied, although those opinions were issued without discussion, they were per curiam affirmed opinions. That's Burroughs, St. Fort, and Bonilla.
Counsel, let me before you jump into the exclusive use, personal use part. With regard to the relationship between the going and coming rule and the traveling employees provision, my reading of the briefing with regard to our decision in McCormick is that you disagree with its holding, or are you attempting to distinguish it?
Distinguish it.
Okay. All right. So can you tell us how you distinguish it
From McCormick.
Yeah.
All right. Well, I draw the distinction in this way. Mr. Colon was clearly clocked out. His day was done. He was finished. He was going home. Ms. McCormick was sent on assignment to do some audits for the state. The opinion makes it very clear that she received a per diem for her travel and her work outside of the office. She was compensated by paying paid mileage for the use of her vehicle to go to and from that assignment. And therefore, the court felt that that fell outside of the going and coming rule and was a series of distinctions that justified bringing it outside the act or the statute.
Is there a distance aspect to any of this? Like, I understand this case to be about a service provider in a metro area, versus a traveler, or is that not a somebody who goes outside of an area and travels across the state or to other states? Or
Right. Well, prior to the statute passing, there were a whole series of cases that got into that very discussion. Were they off-duty? Were they traveling an unusual distance? There are cases where they went to dinner and were injured. They went to get a drink and they were injured. Those kinds of cases were out there. I'm not aware of a case that has a mileage component to whether or not you are going and coming from work. Clearly, in this case, the evidence was undisputed that he drove to the office every morning, got whatever he needed for the day, went out on his assignments, and then went home.
So
And
do you
then
think,
reported the
do you
next
think
day.
McCormick would have been different if they had just told McCormick, hey, we need you to go to a place 100 miles away and come back? No, we're not going to give you a per diem. No, we're not going to pay for your mileage. It's just part of your job.
Well-
And then she was on her way home when the
Okay,
crash came.
well, I'm not sure about that, but I do know that the bringing, going, and coming into the traveling employee statute, this court has focused on the exclusive personal use of a vehicle that's not necessarily owned by the employee. If I drive my car to and from work, I'm not covered. None of us are. Now, there are some cases that when I drive my car to a deposition, I would be covered historically. Of course, those were pre the statute, but it's clear that he had completed the day's assignments. He'd completed the day's work. I understand why you could compare it to McCormick and say, well, that's the end of the conversation. But I think the difference based on the way this court has addressed exclusive personal use in these other cases, either by affirmance or by opinion, Wilcox is another example where this court upheld a denial based upon someone who was returning home, that there is a distinction between McCormick. Obviously, there's a distinction between McCormick and Wilcox.
But there's no issue in McCormick about the exclusive personal use of the vehicle.
No, it doesn't appear that came up because she was driving her own car.
Right, so
And these are all-
presumably her own car would qualify then. If we assume it does,
Right.
then the issue really doesn't turn on exclusive personal use of the vehicle. It's about how we define what traveling is and its relationship to going and coming.
Yes, that's true. That if the essential argument is whether they're traveling to and from home, as opposed to either the vehicle or what the statute contemplates, then that would be the question that needed to be answered. And there may not be any distinction. I'll have to say that there may not be one if that's the focus. But exclusive personal use apparently did not come up in McCormick in any way, shape, form, or fashion,
Now, in
as I read the opinion now.
As I read Wilcox seems to define exclusive personal use in terms of whether there are no restrictions on the usage of a car. In the vein of my personal car, I can do with it what I want. I can drive here, I can drive there, weekends, weekdays, regardless. And so that if I get a car from my employer, and similarly, I can take it here, I can take it there, just like a personal car, then
Right.
that's exclusive personal use. Am I reading that correctly?
These cases seem to turn on that, Your Honor, that if there's a company car involved, which is essentially signed out to the employee. I mean, all of these cases talk about that the employee is not supposed to use the car as a personal vehicle, although it seems clear that in every one of these cases, they were allowed to use it for personal purposes in a minimal kind of environment, if you will. There was one case that talked about they couldn't use it to take to football games and tailgate and things like that, but if you jumped in the car and ran to Publix one day, that didn't blow anything up. Just like the use of the car on the way home might bring it into or outside the going and coming rule because of dual purpose, those kinds of issues.
So do I read Wilcox right, that there are two categories for exclusive personal use? uses that are restricted and uses that are not restricted? Is that the universe,
As opposed to whose vehicle it is?
as opposed to whose vehicle?
Yeah. It seems that as long as the use of the company vehicle is restricted to basically business, then these cases seem to say that they are not compensable if you were injured in the vehicle going or coming, absent some other exception or alternate reason, like dual purpose. It was cited in this case that each of these technicians at one time or another have to go on call. All right? So their day's over, they're headed home, they're done. They have to go back out. Or on the way home, they get a call and say, you need to divert to this. That would be covered by the traveling employee rule. The Longo case would probably come into play, and that would be a compensable injury, it seems to me.
Let me ask you, with regard to the exclusive personal use, is it your position that the exclusive personal use analysis should be viewed in the context of unlimited outside of working hours use of the vehicle, or is it exclusive personal use for the purposes of traveling to and from work?
It seems to me these cases tie it to the fact this vehicle has been assigned to you for your use. In other words, it's not a vehicle I drive today, you drive tomorrow. Ms. Blenderman drives it on Friday for the company. It's exclusive personal use. It's assigned to you. Maybe that's a poor choice of words in these opinions. Maybe it should be a different word. But as I read these cases, if the vehicle's assigned to you for your use for company purposes, then an injury under the going and coming rule wouldn't be compensable. So, and that's one of the issues we're here on, is that these cases somehow need to be reconciled, it seems to me. You've got 3 that are PCAs that seem to uphold the denial of benefits under going and coming. So, but anyway, I mean, we haven't gotten into the other issues, but I'll save the remainder of my time if there are no more questions right now. Thank you.
May it please the court, my name is Nick Shanane, and I, together with Chris Mazzalotti, trial counsel below, represent the appellee, Dorinda Colloon, the mother and guardian for the injured employee, Aaron Colloon, in this case. We just heard questions about the going and coming rule, and specifically the exclusive personal use question, and we completely agree. That is the core of what the issue is, and that is the core of what the JCC found his findings of fact on. And the critical distinction to be made here is that those are findings of fact. This is a competent, substantial evidence question, and whether the vehicle was exclusive use of the employee or not depends on a number of factors. And we heard about, opposing counsel refers to these cases that are in doubt, and none of those cases are actually before this court, because those cases were, as noted, per curiam affirmed decisions that cannot be used as precedent. We can't look behind the curtain. Preservation issues, all sorts of other reasons may well have factored into why those decisions were affirmed. But the critical part there is they all involve the word affirm. And the reason why the word affirm is so important is because on competent, substantial evidence questions, it is this court's view that this court does not reweigh the evidence, that's not the function of the appellate court.
Counsel, let me take this to a legal issue as opposed to a competent, substantial evidence issue. Now, let's just forget about the case law for a second, because I've been struggling just with the language of the statute itself, which I'm going to waste your time a little bit by actually reading it. It says an injury suffered while going to or coming from work is not an injury arising out of in the course of employment. Okay, right there we've got a rule of law. It's not covered.
Correct.
Then we've got some conditions, maybe 2, maybe 3. The courts seem to have considered as 3. Whether or not the employer provided transportation. Okay, I get that.
If we stopped there, it would have changed. But
then the one we're going to get into, but I'm going to skip it, unless they were engaged in special errand. Those both make a lot of sense to me.
Sure.
But then we've got this middle one, which is at issue here. If, not unless, if such means of transportation was available for the exclusive personal use. Now, my reading of that, I think you know where I'm headed, is that it certainly sounds like, if you interpret it this way, the only time the going or coming rule applies is if, I lost my place, if it was available for exclusive personal use. That is my reading of what the case law says. It does not make sense to me because clearly it should not be the only time this rule applies is if you have exclusive use. If I shared a car with my wife, I don't have exclusive use.
Correct.
So the way I see it is that it's not a very well-written statute, but the first two exceptions are actually read together. Whether or not the employer provided transportation, if such means was available for exclusive use, personal use. In other words, that the fact that it was exclusive personal use does not exclude you. You fall under the whether or not the employer provided transportation. Do you have any comment on this? It just seems to me that the case law is suggesting that this is a condition of the coming or going rule instead of an exception to it.
The case, first, I would like to agree with Your Honor. This is a statute for which a comma or a sequence of numbers delineating exceptions would certainly be of use, and that would be welcome. But the Florida Supreme Court has addressed the issue of that particular exception, the exclusive personal use, in the Schwartz versus McDonald's case. And in that, they say that they've interpreted it, and Your Honor's interpreting it consistent with that decision, but asking, can the statute be looked at differently? And it can, and that's always troubling. We would like statutes to be plain meaning controls, and we can simply read the statute and know precisely what's intended. Fortunately, the Florida Supreme Court has looked at this particular thorn and decided that the rose is still a rose. They've specifically stated that the employer provided transportation exception, which is specifically referenced in the statute, permits recovery, or compensability in this case, where the employer provides the employee's transportation to and from work. And then they go on to state that the same statute eliminates this exception. So they're calling that an exception when the means of transportation is available for the employee's exclusive personal use. So the Florida Supreme Court has looked at this, has felt the need to explain what's going on here because of the potential ambiguity within the statute. But because of the clarity of their statement and a reasonable reading of the statute, it's clear that where exclusive personal use does not exist, where an employee does not have the ability to use the vehicle as the employee wants, then clearly, as interpreted by the Florida Supreme Court and this court in its decisions in actually Wilcox even though it's the case cited by the appellant, it's a strong case for the appellee for a number of reasons. It stands for the proposition that this is a factual determination to be affirmed if there's competent substantial evidence. It stands for the proposition that based upon the evidence admitted at the hearing, the JCC specifically found that the personal use of the vehicle was allowed and intended to be part of the claimant's compensation, and no practical restrictions on the claimant's use of the vehicle was an important criteria in Wilcox. Here, there were lots of conditions on his use. He was told you can't smoke, you can't drive anyone, you can't take the van anywhere but on your use. You can only refuel with this card, so we can keep tabs of exactly what you've been doing. And if your card shows you've been going out of bounds, we're going to let you know about it.
Well, the court in Wilcox is saying that those things are sufficient, not that they're necessary.
That is correct, and I think this is important that going back to the Schwartz case, the Florida Supreme Court recognized specifically that how factual this question is, that it's not a magic of one factor is required or this. The judge needs, JCC in this instance, needs to be able to look at all of the facts in the case. And in Schwartz, the court held that the applicability of the going and coming rule, along with the exceptions, and there are several, depends upon the nature and circumstances of the particular employment, and no exact formula can be laid down which will automatically solve every case.
Is there anything that you can point to that clearly explains what exclusive personal use is to mean? Specifically with regard to the question that I asked previously, does it mean exclusive personal use for traveling to and from work? Or does it mean exclusive personal use as in I can take my family to Disney World in the car?
And the latter has been what the case law has suggested, that it is about whether...
Well, not that the case law suggests. Is there anything that you can point to that clearly answers that question?
We look at the Wilcox decision and can reflect backwards upon it. We look at the Swartz decision. We can look at the McCormick and Longo decisions are more on the traveling employee side than the exclusive use side. So instead, I think we have to just look at the facts of this case. And in this case, we have three and only three people who testified. We have the owner, we have the office manager, and we have the adjuster. And all three said that the employee could not use the vehicle for his own personal use. All three said that was a condition of employment, was that you use the vehicle only for personal use, only for business use. And I think it's relevant that the employee had to do a signed employment agreement, had to do a signed fuel card agreement, had to do a signed vehicle use agreement. And the vehicle use agreement says specifically, I will use the company vehicle only for company business and never for personal use. He did not have exclusive personal use. This could not have been drafted to be more parallel. The employment agreement has a section for automatic dismissal. You violate these bullet points, you're gone. There's only two of those bullet points that the employer decided to underline to add additional emphasis. One of those two underlined provisions is, in the case of commercial drivers, transporting unauthorized passengers in company vehicles. If he had personal exclusive use, he could bring his wife, he could bring his mom to crochet, he could do what he wanted with the vehicle, and that would be, exclusive personal use. He would have the right of doing that. Here, he had none of these things. In fact, if he did that thing, if he took his mom to crochet club, automatic dismissal is a remedy here.
Although there's also testimony that he was permitted to use it for incidental personal use, right? And in a somewhat similar way, in Wilcox, you have lots of rules also, like the kind that you're talking about that limit the use of it, but there was testimony that indicated that it wasn't enforced at the time, and the JCC found that was sufficient, and our court affirmed.
There the JCC found, and again, this is the factual question that's for the JCC to make that factual determination. There the JCC did find that there was, quote, no practical restrictions on the claimant's use of the vehicle. Here, at best, the employer might not come down with a hammer if he, stopped at a grocery store for a gallon of milk on the way home. But other than fueling, there's no specific allowance, and he's supposed to get authorization in writing by each of these policies. There was hypotheticals asked of the owner and the employer who spoke vaguely of possible things, but it was clear that if he decided to use his vehicle as he personally wanted to, and of course this vehicle couldn't be used in a truly personal manner anyway. It's loaded with work equipment. It's wrapped with the Kelly Air insignia. It's simply not a vehicle built to be your fun personal vacation vehicle.
Unless personal means something different. Unless personal means the company is doling out vehicles to each employee, and each employee's vehicle is personally for your use on the job. And if personal means that, and not personal home use, then it's a different analysis.
I would say that would be inconsistent with the written cases, not necessarily the PCAs. But I would say even under those circumstances, that still doesn't apply to this case. The employer was clear that he has the right to pull your vehicle, use it for someone else, that he has the right to go to your house, open up your vehicle, get tools out, and close the vehicle.
But that was true in Wilcox also, right? That other people were also permitted to use the vehicle at times.
And again, this is why we must return to the CSE standard. And we've heard the citation to Wilcox, we've heard the citation to Gulbertson. Both of those cases talked about the competent substantial evidence standard. So all I'm trying to indicate with that is that if this court wanted to transform the personal part of exclusive personal use to one person, one car, that wasn't what Wilcox hung its hat on, and it wouldn't really match the facts of this case. He didn't have he wasn't allowed to say, this is my car, and I can control it even for my limited purpose of going to and from work. The employer could step in any time he wanted. So I don't believe, even under that kind of a reading, which would not fit the meaning and the purpose, the coming and going rule would be vitiated if the exception to the coming and going rule for that category of class, that if you're an employer who's going to give a vehicle for the specific limited purpose of work, the statute's been written to make clear, well, at least as clear as it can be interpreted by Swartz and the similar cases, that the vehicle should be used, if it's exclusive personal use, meaning you can use it however you want, it's out. But otherwise, then by definition, that going and coming is important. And Your Honor asked an interesting question about the distance. And it's correct that there is no magic number, but it's clear that that was something that the JCC properly took into consideration. That was the same kind of consideration that happened with Ms. McCormick in traveling her great distance.
Can we assume for a second that it is available for his exclusive personal use, or that it does qualify otherwise under subsection 2? And can you speak to how you think the traveling employee provision would apply to these facts?
Certainly. If for some reason it didn't, the judge was also clear, made separate findings of fact that he was in fact a traveling employee, that he was very similar to the employee in Longo, where it was compensable, even though unpaid at the time, which is important here, that I would argue that he should have been paid for his time traveling from a long distance back to either home or the office, but that's not this particular employer's decision. That cannot control.
Well, in Longo, he's going from one job to another job. He's not going to or from the house, or
actually, he was, I believe, going to his
eating, right?
Going to eat, so he was off the clock, going to a place that wasn't anywhere that was on the employer list of places, so he could have
But
lunch
he had
or dinner.
a job after.
And he did have a job after,
So
but I don't believe that that's a distinction that can remove the applicability of Longo or McCormick from the traveling employee analysis. That here it's clear that the going and coming rule does not apply to traveling employees, so says this court in Longo, whose duties consist of local travel without a fixed site of employment. The employer carrier argues that, hey, he does have a fixed site of employment. He has to stop in at his office at the beginning of the day, and the JCC made clear that that's incidental to his actual duties. His duties are not to fix something, go to work, clock in, and work the machine. His duties are to go to work to pick up the papers and then go across a 4-county span with distances that can be 100 miles from Naples to Collier to all over that region. He is a traveling employee, probably with a longer spread than the employee in Longo. And it was clear, this court said in McCormick, that we declined to construe the traveling employee statute to allow a going and coming exception that would abrogate workers' compensation coverage in every case once the employee begins travel home. They said, we're not buying that. That's not our reading of the statute. And this court agreed with that again in Longo. And the judge of compensation claims below properly applied those constructs to provide a second reason why this court should utilize the competent substantial evidence standard and affirm. For each of these reasons, we respectfully request this court to affirm and allow the lower court to proceed on the remaining matters pursuant to the bifurcation order. Thank you.
Thank you, counsel. Appellant's counsel, and let's add 1 minute to appellant's counsel's arguments to compensate for the overage just there. Thank you.
All right, Your Honor. We seem to be hung up on exclusive personal use. And I didn't write the statute. If I had, I wouldn't have used that word because it conjures up the idea, this is my car, I can do whatever I want with it, and otherwise it doesn't come under the statute. It seems that all of the cases thus far discuss or seem to recognize that when the vehicle is assigned to an employee for their use in business, and I don't think any of these cases have said that the employee was allowed to take the car to Disney World. In fact, there were always restrictions, whether they were written down or were matter of practice that the employee had limitations on what they could do with that vehicle. Now, in terms of the standard of review, we take the position this is a de novo review because there are no real disputed facts here. And the issue seems to come down to, are we going to use the going and coming rule and the traveling employee statute to bring everybody who gets injured on the job into the comp system, or are we going to apply the statute the way it's written, which is we're going to treat traveling employees who are, as was clearly stipulated in this case, off the clock, going home, as not having had a compensable accident because of the going and coming rule. Now, people can argue the going and coming rule ought to be thrown out the window, and I realize that you are trying to parse this statute whenever a traveling employee comes into the picture. It's very easy to say it's going and coming when you leave the house, go to a fixed place of employment, and return. Well, we now know that that's not the real world any longer, as this court decided in Valcourt, that you've got other issues to deal with now with remote traveling, off-site, those kinds of issues. But we still have to apply the statute. And the statute seems to say that you have to apply it in a way that's consistent with what this court's already done. And we take the position that's not what this judge did here. His rationale, longo compensation issues do not comport with what this court's previously ruled. And therefore, we take the position that this was reversible and that the judge maybe thought he was pulling out some strings to get it outside of going and coming, but he specifically ruled that the dual employment, the other kinds of well-recognized exceptions did not apply here. And there doesn't seem to be any requirement in any of these prior cases, which you've ruled on or which are PCAs, in which the distance issue was a determinative factor. So we don't think that's a determinative factor in this case as well. So without any additional questions, then I'll stop here and ask again that you consider reversing this case and sending it back to the judge for a ruling consistent with the statute.
Thank you. And that concludes our slate of cases for today, so we will be adjourned.
All right.